Before any DUI arrest, there is a traffic stop. That stop has to be legally justified. If it was not, everything that came after it, the field sobriety tests, the breath test, the arrest itself, can potentially be challenged in court. Police do not need proof you were drinking to pull you over. They need what the law calls reasonable suspicion, meaning specific, articulable facts that something illegal might be happening. A hunch is not enough. But a lane drift, a wide turn, or running a red light usually is. Checkpoints work under a separate legal framework. California courts allow them even without any suspicion about an individual driver, as long as the agency follows specific rules, like publicizing the checkpoint in advance and stopping vehicles in a neutral, predetermined pattern. If those rules were not followed, the stop may not hold up. Reasonable suspicion gets the officer to your window. To actually arrest you, they need a higher standard called probable cause. That usually comes from what they observe during the stop: the smell of alcohol, slurred speech, red eyes, or a failed field sobriety test. Each observation they document builds or weakens that case. If the original stop lacked reasonable suspicion, a defense attorney can file what is called a motion to suppress under Penal Code Section 1538.5. That is a formal request asking the court to throw out evidence gathered because of an unlawful stop. If the motion succeeds, the prosecution may have little left to work with. Results vary case by case, and there is no promised result. Understanding whether your stop was legal is one of the first things a DUI defense attorney looks at, and it can shape the entire case. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.